Good afternoon, friends. Important judgment coming from Odisha High Court. If supplier has wrongly furnished B2B supply, registered supplier to registered recipient, as B2C, while furnishing his GSTR1, and that too for the period September 2017 and March 2018. So quite obvious, this is not going to be auto-populated in GSTR 2A of the recipient. And we have seen that lot of dispute, lot of scrutiny notices, lot of so-called notices are being issued to the recipient for denial of credit, which is not getting auto-populated in GSTR 2A of the recipient. So question which was raised before Honorable Odisha High Court was, first, whether the GSTR1 time limit is prescribed within the GST law under section 37, which is by September of next financial year following the end of relevant financial year. But for your information, this period is now 30th November as per amendment made by Finance Act 2022, but we are referring the period 2017-18. So last date for availment of credit for 17-18 was 31st March 2019. So at most, this supplier could have rectified any omission or error by 13th April 2019, but he only came to know by January 2020 that he did the mistake, and now the time period to amend his GSTR1 for 17-18 is gone. He can't amend that. So credit was quite obvious, being denied for the recipient, not getting auto-populated in his GSTR2A. So issue which is decided by Honorable Odisha High Court. What is being held in this judgment is a very good judgment, and to my mind this should be the legal position as on date. First, this supplier, though he has wrongly furnished B2B as a B2C, but he has paid the tax to the government exchequer. Tax तो उसने जमा कराया है. So it's a revenue neutral transaction. No loss to the government exchequer. Even if it is allowed that his GSTR1 can be amended beyond the due date. And why he should be allowed? Reason number 2. That when we have implemented GST on July 1, 2017, we have envisaged there would be automated GST return system which is going to cross-check and match ITC when GST charged by the supplier, corresponding credit in the hands of recipient. And the process I have discussed in number of videos. GSTR1 by supplier getting auto-populated in 2A for the recipient. Recipient can add, modify and delete while filing a GSTR2. And once recipient is doing add, modify, delete while filing GSTR2, it gets auto-populated for the supplier in GSTR1A. So supplier either has to accept or reject while filing GSTR3, and corresponding section 37 GSTR1, 38 GSTR2, 39 GSTR3 initially, but with retrospective date they have introduced GSTR3B, 42 and 43. It is all in conjunction with each other. We have to read all these provisions in conjunction with each other. Holistic provision. But we all know that GSTR2 and GSTR3 never got implemented. So in a given situation, the correction which supplier could have done, because if he is wrongly furnishing B2B as a B2C, then quite obvious that recipient could have corrected while filing GSTR2, and it would have come to the knowledge of the supplier and he would have accepted through GSTR1A. This automated return system was never implemented. Can we penalize? Can we say time limit as prescribed under section 37 can be read independently? To my mind, no. In my humble submission, no. Being revenue neutral transaction, taxes are being paid to the government exchequer. Just because B2B wrongly furnished as a B2C, you will not be allowing me beyond due date because you have not implemented automated GST return system which was envisaged for ITC matching and mismatching. Honorable Odisha High Court has held that this supplier can amend his GSTR1 which he has wrongly furnished B2B supply as a B2C even beyond due date. And it was held as a revenue neutral transaction and there is no loss to the government exchequer. Quite obvious. And secondly, if Assessee unnecessarily prejudiced that this credit is not available, then that is not the right proposition. Thereby, Assessee, the recipient, must get the credit because he is satisfying all the conditions having tax invoice, which is B2B invoice, receipt of goods and services. His supplier has paid taxes and recipient was regularly filing GST return under section 16 subsection 2. So GSTR1 को beyond due date amend कर सकते हैं. B2B supply जो wrongly furnished कर दी B2C, it can be amended even beyond due date. Honorable Odisha High Court has relied Madras High Court judgment. Sun die came, but to invite your attention and for your information, recently Jharkhand High Court has also allowed that GSTR1 can be amended beyond due date on similar plea revenue neutral transaction and there is no loss to the government exchequer. In the case of Mahalakshmi infra contract. But for you to know that Telangana High Court has denied, they are saying and they are relying Bharti Airtel judgment of Supreme Court saying beyond due date GSTR1 can't be amended in Yokohama India Private Limited. Recently, Calcutta High Court has allowed that GSTR1 can be amended in TMC High Tech, that is the judgment coming from Calcutta High Court. To my mind, as per my humble submission, it is revenue neutral transaction, no loss to the government exchequer. Since automated GST return system, whereby we can match ITC or mismatch ITC, we can cross-check and verify through automated GST return system was never implemented. Doctrine of impossibility. And it would be unnecessarily prejudiced if Assessee is being disallowed for this particular credit. So having said, this is a very good judgment और इस जजमेंट में ये कहा गया, उड़ीसा हाई कोर्ट ने कहा कि ये क्रेडिट जो बायर को मिलनी चाहिए एज पर सेक्शन 16 सब सेक्शन 2 मिलेगी. सप्लायर ने गलती कर दी बट रेवेन्यू न्यूट्रल ट्रांजेक्शन है, गवर्नमेंट एक्सचेकर को कोई लॉस नहीं हो रहा. So this is one of the good judgment we are struggling with, that wrongly furnishing B2B as a B2C for the period 17-18 and 18-19. Important 2A came only from January 2019. By then recipient और supplier किसी को नहीं मालूम था कि supplier से गलती हो गई है. Even recipient was not knowing about it. So government must consider that such mistake, omission which has been done for the period 17-18 and 18-19, when automated GST return system was not there, then they should allow such credit even though not auto-populated in GSTR 2A. I'm going to make another video that what happened if there's a difference in credit in GSTR 2A versus GSTR 3B, and with the recent circular number 183, and that matter has gone to Karnataka High Court in the case of Wipro India Limited. So another video on same, but thanks for watching. Stay tuned. Thank you very much.